Welcome to the DX Today podcast, where you get facts, not hype.
Yeah.
And I think we need that slogan more now than ever.
Right?
I
Absolutely.
mean, every time I open LinkedIn, every single press release I see, it's just another startup.
With enormous amounts of capital behind it.
Enormous capital. And they're all promising to, revolutionize and automate and just change reality all before the next quarter closes.
It's a complete gold rush.
It is. But the gold feels like it's mostly PowerPoint slides and some very aggressively optimized buzzwords.
Well, it's a gold rush that's being driven by what you could call a collective cognitive dissonance. What's so fascinating here is that the immense pressure from investors, from the market, it's created this environment where the line between, let's say, optimistic marketing, hype, and outright fraudulent misrepresentation, that line isn't just blurred anymore. It's basically invisible to someone who doesn't know what to look for.
And regulators are putting a name to it.
They are. They're officially calling this AI washing. And it's no longer something they're just going to manage with, a corporate fine here and there. They are taking aim at the individuals, the people actually executing the sale.
And that right there is the profound legal shift that we've been tracking through our sources. I mean, for years, the focus was always on corporate liability. You'd sue the company, maybe fine the CEO, and the sales team could generally just hide behind the corporate veil. But what our deep dive into these enforcement trends is showing is that this regulatory triumvirate, the SEC, the FTC, and the Department of Justice, they're now directly targeting individual sales professionals.
And business development execs, solution architects, you name it.
Anyone customer-facing.
That's the critical takeaway here, that traditional prevailing assumption.
Yeah.
The idea that non-technical staff are somehow immune from liability just because they're repeating company-approved marketing messages.
Yeah, I was just reading the script.
That is fundamentally collapsing. If you are the one disseminating a material falsehood, it doesn't matter if you didn't write it. You are now squarely in the regulatory crosshairs.
So what does this all mean for you, the listener? If you're a sales executive, a BD lead, a solutions expert, really anyone closing enterprise deals that are based on AI capability, you need to understand the personal risk you're taking.
Every single time.
Every single time you open a pitch deck. So our mission today, our deep dive, is to really analyze these sources that show the era of fake it until you make it has been completely replaced by a new regulatory regime.
A regime of verify or face liability.
It's a monumental shift in personal accountability, and we really need to unpack how this actually works in a courtroom. So let's start with the root cause in our first section, the actual mechanics of AI washing. Why is this specific issue peaking right now? I mean, we saw bubbles with Web3, with the .com era. What's different here?
It really boils down to two things: the magnitude of the dissonance and the complexity of the technology itself.
Okay, unpack that. Dissonance.
There's just a massive, often multi-million-dollar gap between the technical reality of current AI models, their limitations, their tendency to hallucinate, their reliance on these massive, expensive data sets, and the aggressive commercial claims that vendors are making to secure those huge funding rounds and enterprise contracts. The pressure to just slap AI powered on everything has become the market imperative.
Without that buzzword, you don't even get the meeting.
You don't get the meeting, and you certainly don't get the valuation. And the technical complexity, well, that acts as a perfect shield for the fraud.
Yeah, that makes sense. If I'm selling enterprise SaaS, my buyer, even if they're sophisticated, they might not be able to tell the difference between a genuinely trained large language model and, a really well-written, rules-based chatbot.
Precisely. And our sources break this deception down into, three distinct forms. And the level of legal risk you're taking on often changes depending on which form of deception you're actually executing.
Okay.
The most blatant, and frankly the most cynical, is number one: total fabrication.
The Wizard of Oz scheme.
That's what it's become known as, yes. It's the most brazen form of AI washing out there. It involves claiming you have these proprietary AI models or that a process is fully automated, when in reality, the automation that's in all the marketing materials is being entirely performed by low-wage human workers, often offshore, just manually routing results in real time. The customer thinks they're interacting with this brilliant instantaneous algorithm, but they're just getting results from a human who's rushing to meet the instantaneous turnaround time promised in the contract.
The irony there is it's almost comedic, leveraging human labor to fake automation. But the legal implication is, I mean, it's deadly serious. It's a complete and total lie about the product's very existence.
Exactly. The lie is material to the contract's viability. Now, the second form is a little more technical, maybe more common with established software companies. It's called technical misclassification.
This sounds like calling a horse a unicorn.
That is a perfect analogy. This is where companies do have some level of automation, but they deliberately misrepresent its complexity or its capability.
So they're using simple code, but dressing it up in fancy language.
You've got it. They might be using basic, rules-based software, simple if-then logic, a standard linear regression model, stuff that's been around for ages, but they market it using these hyper-sophisticated terms like self-learning neural networks or generative AI.
All to justify a premium price point.
Exactly. They are leveraging buzzwords that carry a huge dollar value while delivering commodity code that's existed for decades.
Okay, and the third form. You said this one is the trickiest to detect because there is a real product involved.
Right. This is capability exaggeration. Here, a genuine AI model actually does exist. It might even perform the function it promises, but its performance metrics are just grossly and materially overstated.
So we're talking about fudging the numbers on accuracy, on speed, on autonomy.
You see this constantly. They might claim, 99% accuracy on financial projections when their internal testing barely hits 70%. And even that 70% relies on human experts who are constantly correcting the output.
Or the big one, autonomous.
The autonomy claim is huge. They'll say the system is autonomous when, in fact, it requires human intervention or review, say, 80% of the time, just to prevent catastrophic errors. So the model is real, but the claims made about its functionality, the very things the customer is buying, are outright falsehoods used to close deals.
Okay, and here's where we need to stop and really emphasize the legal risk for the individual sales professional. Our source analysis hammers this home. The danger lies in the materiality of these distinctions. I mean, why does a regulator care if I call a linear regression model a neural network?
It matters because of the legal concept of materiality. Materiality just means that the fact in question, the claim, is one that a reasonable person would use to make a significant decision.
Like buying a multi-million-dollar software platform.
Exactly. When customers purchase a high-value solution for, say, high-frequency trading or medical diagnosis, they are relying entirely on those specific technical characteristics. They need a self-learning neural network to handle dynamic variables. A simple rules-based system just can't do that job.
So misrepresenting a rules-based script as a self-learning neural network isn't just fluffy marketing.
No.
It's a lie about the core functionality that the buyer is paying millions of dollars for.
That's exactly it. When a salesperson makes that misrepresentation, they are deceiving the buyer about the fundamental nature of the product. Regulators see that discrepancy not as mere puffery, not just optimistic marketing, but as fraud.
Because the technical specs are the material facts.
These are the material facts the client relies on to make that purchasing decision. If you claim your AI predicts market trends with unsupervised learning and it turns out to be a consultant in the back room running an Excel spreadsheet, that lie is material to the investment decision, and you are liable for the fraud.
So now let's map out what you called the federal enforcement trifecta. Because this isn't just one agency occasionally poking at a startup. It's a coordinated strategy, which has to increase the legal risk exponentially.
It does. You can be sued or charged simultaneously by multiple bodies. The first, and maybe the most aggressive, is the one tasked with protecting the investment side, the Securities and Exchange Commission, the SEC.
Right, and they're worried about the capital markets.
They're worried about market integrity. The chair, Gary Gensler, his warnings have been explicit. He's basically said investment advisors should not mislead the public by saying they are using an AI model when they are not, especially when the use of that AI is central to their whole investment strategy.
He sees false AI claims as directly manipulating the capital that fuels the entire market.
He does. And we don't need to look far for precedents. The sources are highlighting enforcement actions against companies like Delphia and Global Predictions. These aren't just threats, they're active examples of what's happening.
So what happened there?
These are crucial cases to watch. Delphia and Global Predictions were fined a combined $400,000 for falsely stating in their marketing and their regulatory filings that they used collective data and sophisticated AI to predict market trends. The problem was
those capabilities didn't exist.
They simply did not exist. For the SEC, this wasn't just some internal policy issue. This was misleading investors about the core competitive advantage of the business.
Okay, now let's turn that lens toward the individual. If I'm a business development executive at, say, a Series B fintech startup, and I'm selling to a VC firm or trying to attract limited partners, How does the SEC come after me? I'm not the one writing the 10K filing.
The liability comes from your direct role in the solicitation process itself. If you, as that business development executive, use a pitch deck that has false AI claims and it claims about proprietary algorithms or trading data size, prediction accuracy.
The things that get VCs excited.
The things that get them to write the check. If you use that deck to secure venture capital, you are potentially liable for securities fraud. Your actions contributed to a scheme to defraud. The key is whether your AI claim influences that investment decision.
And given the current frenzy for AI funding, that claim is almost always material.
Always. The SEC will argue you were soliciting investment based on a material falsehood that you either knew was untrue or you should have known was untrue.
So just disseminating the false claim in that pitch meeting makes you culpable, even if the marketing department wrote the slide.
We'll get into the death of that messenger defense later, but yes, that's the vital thing to understand about the SEC's reach. It's defined by the investor's reliance, and right now, investors are relying very heavily on AI's claims.
Okay, moving on to the second part of the trifecta.
Yeah.
The consumer and business-to-business side. That brings us to the Federal Trade Commission, the FTC.
Right, and their focus is protecting consumers and businesses from deceptive practices. The FTC chair, Lena Khan, has made it unequivocally clear there is no AI exemption to the existing laws.
So Section 5 of the FTC Act.
Exactly. And the FTC is acting preemptively. They've launched specific, named initiatives, most notably Operation AI Comply, which directly targets companies that use AI hype to deceive the marketplace.
Often by promoting capabilities that are just fake or exaggerated.
That's right. But the personal risk for sales staff here is a little different than the SEC's focus on investors. The FTC is focused not just on making the lie, but on providing the tools for deception.
The means and instrumentalities doctrine.
That is the critical distinction here. The means and instrumentalities doctrine is hugely powerful. It holds that anyone who provides the means for others to commit deception is also liable.
Okay, give us a concrete scenario for that. Something relevant to enterprise sales.
Sure. Imagine a salesperson who sells a highly sophisticated platform that generates synthetic training data. Now, let's say that salesperson knows, or really should know, that this platform's primary use in the market is for their clients to create deepfake testimonial videos or fake product reviews on a massive scale.
So their clients can deceive their customers.
Precisely. So even if the core technology itself is legitimate, if the salesperson knows the product's main application is deception, they are liable for providing the mechanism for that deception.
So by facilitating the sale, selling a tool whose fundamental purpose is fraud, the individual salesperson contributes directly to the scheme.
Yes, even if they never wrote a single deepfake testimonial themselves, you sold the weapon that allowed the crime to happen.
And finally, the third, and maybe the scariest part of the trifecta, the Department of Justice, the DOJ. This is where we move from fines to criminal charges.
This is where we move from civil fines to handcuffs, yes. The DOJ leverages existing, very broad statutes, particularly wire fraud and mail fraud,
which are triggered in almost any modern business deal.
It's a certainty in enterprise AI sales. Any electronic communication or transfer across state lines can trigger it, and the Deputy Attorney General, Lisa Monaco, has explicitly directed federal prosecutors to actively consider stiffer sentences for white-collar crimes that use emerging technologies.
So this isn't just about punishing a crime that happened. It sounds like a policy imperative. They're actually motivated to go out and charge these cases.
They are highly motivated, and it's driven by this policy concern they call false innovation. Regulators see these false claims about AI as doing double damage.
How so?
First, you defraud the immediate victims, you take their money. But second, and what they see as more damaging to the economy as a whole, is you poison the well for legitimate innovators.
Right. When every startup is claiming magic, investors and customers become skeptical of real breakthroughs.
And that slows down the whole economy. This policy priority means the DOJ wants to make very public examples of individuals. So a salesperson selling vaporware should not expect any leniency. The enforcement here is designed to be a strong public deterrent.
That really sets the regulatory battlefield. So now let's drill down into the legal architecture itself. How do regulators and plaintiffs actually bypass the corporation and go straight for an individual's personal assets? This brings us to Section 2.1, the direct participation doctrine.
Right, and this section addresses the central myth in corporate America, what we're calling the just a salesperson defense.
People really misunderstand what the corporate shield is for.
Fundamentally, It is a powerful mechanism, but it protects shareholders from the debts of the corporation. Things like bank loans, vendor bills, standard breach of contract claims. It does not protect an employee from personal liability for the torts they personally commit.
So if I am an employee and I look a client in the eye and lie about a proprietary AI model that I know doesn't exist, I have personally committed the tort of fraudulent misrepresentation.
Correct. Under the direct participation doctrine, corporate officers and employees are personally liable for the torts they commit, even if they were doing it for the corporation's benefit, to close a deal and make money for the company.
So the fact that my CEO told me to lie or that marketing wrote the script.
It simply means the CEO and marketing are likely also liable. It doesn't absolve you.
And our sources cite cases about this that are, seemingly mundane, like a used car case, Clark Auto Co. v. Reynolds. How does a used car case inform our understanding of AI fraud?
Well, we cite that case not because of the product, but because it proves the fundamental principle of personal accountability. In that case, the agent was held personally liable for misrepresenting the condition of the vehicle, even when the jury found he didn't actually know the statement was false.
Wow, so that's strict liability.
It demonstrates the potential for strict liability for what's called innocent misrepresentation. And if a sales agent is personally liable for lying about a par's transmission, the same principle holds true, only with orders of magnitude more severe financial consequences when you're misrepresenting a multi-million-dollar neural network. The complexity of the product doesn't create immunity. If anything, it raises the duty of care.
So if I'm selling high-value, complex AI software, I can't rely on my corporate status to save my personal finances. My actions are my own.
That's right. But to prove the most serious charge actual fraud, a plaintiff does have to satisfy a very high legal bar. They have to prove 6 distinct elements.
Okay, let's review those for fraudulent misrepresentation.
They must prove: 1, a representation was made. This software uses unsupervised learning. 2, the claim was factually false. 3, scienter the mental state. 4, intent that the buyer rely on the claim. 5, the buyer's actual reliance on the claim. And 6, resulting damages.
Let's focus on number 3, scienter. That sounds like the big one. This is often the shield that protects salespeople, right? It means you have to prove the salesperson knew the claim was false or at least acted with reckless disregard for the truth.
It is the high bar. But this is where we introduce the crucial pivot: the red flag doctrine. The law recognizes that a salesperson cannot simply manufacture ignorance to protect themselves. You can't intentionally put on blinders and expect to be treated as an innocent party.
So what constitutes a red flag in the context of enterprise AI sales? What should people be looking for?
It's quantifiable evidence that directly contradicts the marketing claim. For example, if the engineering team explicitly refuses to sign off on specific performance metrics in an SOW, or if the product consistently fails during live, non-scripted demos.
Okay.
Or if internal audit logs show human staff are manually cleaning the data 90% of the time, despite claims of full autonomy. Or, if customer churn is sky high and the notes all say product not performing as promised.
So if a salesperson sees these obvious signs but continues to pitch the product as flawless and autonomous,
the law can impute knowledge to them. You are, in effect, saying that willful blindness, the deliberate choice to avoid confirming the lie, is treated by the courts as actual knowledge in a fraud trial.
you chose to disregard the evidence.
That's the core of the doctrine.
But sometimes a plaintiff can bypass that high bar of fraud entirely by proving negligent misrepresentation. And that has a much lower burden of proof, which is, frankly, terrifying for anyone in sales.
It is. Negligent misrepresentation only requires that the salesperson failed to exercise reasonable care in communicating the information. You don't have to prove they intended to deceive or that they were reckless. The key here is the duty of care.
And what defines reasonable care for a sales professional selling millions of dollars of AI software? It can't be the same as for a retail clerk.
It's not. The courts view sales professionals selling complex, high-value enterprise software as having a higher duty of care, especially in regulated sectors like healthcare or finance. They are expected to perform a basic level of due diligence and understand the material functions and limitations of what they're selling. They're high-paid experts, and they're held to an expert standard.
And this leads to the most terrifying personal risk of all, innocent misrepresentation.
Yes. In a significant minority of jurisdictions, courts actually allow recovery for innocent misrepresentation. This is a form of strict liability where the plaintiff doesn't have to prove the salesperson knew the statement was false or even that they were negligent.
Wait, so you mean I could be repeating a lie that I genuinely believed, a lie that came straight from my marketing department, and I could still face personal liability for millions of dollars?
In certain jurisdictions, that is the definition of liability for innocent misrepresentation. If your false statement induced a contract and caused damage, you can be held personally liable. Ignorance is not a defense, it's just financially catastrophic. The burden shifts entirely to the salesperson to ensure the material claims they make are true, period.
This classic legal distinction, the difference between vague optimism or puffery and a specific verifiable claim, a material fact, that seems like a crucial legal battlefield. And in AI, that battlefield is expanding fast.
The line is shrinking dramatically because AI claims are inherently technical and precise. Courts will generally dismiss claims that are subjective, like, we are revolutionizing the industry, or the future of AI is here.
Non-actionable puffery. No reasonable buyer relies on that.
Exactly, but the moment you embed specific data points into that optimism, the legal risk just skyrockets. You cross the line into material fact when you make specific, verifiable claims about the system's architecture or its performance.
Like trained on 10 billion parameters.
Precisely. Or we use a proprietary neural network architecture, or the model achieves X% accuracy on financial forecasts. And the critical one, the AI output is reviewed by human experts 100% of the time. These are all high-risk material facts. They're specific, they're verifiable, and if they're false, they constitute misrepresentation.
Which brings us back to what you call the autonomy trap.
Yes. When a salesperson claims a system is autonomous, they are making a specific, verifiable claim that the system operates without human intervention or oversight. This is a material fact, particularly in regulated industries where human review is mandatory.
So if human prompts or review or manual data cleansing are required for the system to work right, the claim of autonomy is a material misrepresentation.
It's a fundamental lie about the cost and the operational model of the product. We saw this in the SEC's charges against Junko Diversity, Inc. They claimed automated recruiting when humans were doing the sourcing. The regulator viewed the claim of automation itself as a factual claim, not a marketing buzzword. If the machine requires a person to function, the claim of autonomy is false, and that falsehood is material.
So let's get back to the harsh reality of litigation. When a high-value enterprise deal goes south because of AI washing, the plaintiff's lawyer typically sues both the corporation and the individual sales executive. Why do they do that?
It's all about strategic leverage. They sue the corporation because it's the deep pocket. That's where the money is to pay a massive judgment.
Right.
But they sue the individual, the bad actor, for leverage. It's to ensure maximum discomfort. An individual defendant can't just easily settle a personal lawsuit with corporate funds without intense scrutiny from the board. That creates internal pressure, internal conflict, and it often forces a faster, more favorable settlement for the plaintiff.
And even if the company promises to protect its employees, there's that existential personal financial threat lurking in what you call the indemnification trap.
This is often the greatest personal financial risk for an executive. Corporate bylaws and employment contracts. They usually promise to indemnify or protect employees against legal costs.
Sure.
But these protections virtually always contain an escape clause. The famous exceptions for willful misconduct or criminal acts.
Right. And fraud is a willful act.
By definition. So if a salesperson is found liable for fraud, the company may legally refuse to cover their legal fees or any judgment against them. And the company's legal counsel, often hired by the insurance carrier, has a fiduciary duty to the company, not to the sales executive.
So they can turn on you.
They can and will argue the executive acted willfully to benefit themselves, say, to get a massive commission while exposing the company to risk, and they can cut that executive off.
So the sales executive, who is just chasing a massive commission check, is suddenly facing multi-million-dollar legal defense bills and judgments all on their own dime. The corporate shield fails at the precise moment they need it most.
And that commission check itself becomes evidence of the willful intent to defraud. It transforms the lawsuit from a corporate nuisance into a devastating personal financial crisis, potentially leading directly to bankruptcy.
We've established the federal enforcement strategy, but our sources strongly emphasize that the most immediate and maybe most dangerous threat to a salesperson's personal assets often comes from the state level. These little FTC acts.
State consumer protection laws are the stealth weapon in this liability environment. They frequently impose a lower burden of proof than federal securities law, but they carry the terrifying risk of treble damages.
3 times the actual financial loss.
Exactly. This is designed to be punitive, not just compensatory. And crucially, these state laws often allow the private party, the customer, to sue the individual salesperson directly without needing a federal regulator to step in.
Okay, let's look at a few key states. Texas first. Given the volume of tech enterprise sales there, the DTPA sounds like a formidable weapon.
The Texas Deceptive Trade Practices Act has extremely broad reach. It allows consumers, and often businesses, to sue any person who commits a false, misleading, or deceptive act. The courts have been clear. Corporate agents, the sales professionals, are personally liable for their own violations. The corporate veil is completely irrelevant.
And what accelerates the risk in Texas is this knowingly standard, which is what unlocks those treble damages.
That's right. If a jury finds the salesperson acted knowingly, which means they had actual awareness of the falsity, the plaintiff can recover 3 times their economic damages, plus damages from mental anguish. The financial incentive for a plaintiff to prove knowledge is just enormous.
Give us a high-stakes AI washing application under the DTPA.
Okay, imagine a Houston-based sales rep selling an untested AI healthcare diagnostic system to a hospital. The rep knows the system has failed every internal stress test, a clear red flag, but they pitch it as having near-perfect, generalized accuracy. If the hospital buys it, and that flaw leads to misdiagnoses, causing, say, 3 patients to suffer significant harm and financial loss, that sales rep could be personally on the hook for 3 times the total damages from those misdiagnoses.
That is a potentially career-ending financial catastrophe, all based on repeating a false claim about the product's core function.
Moving to the Northeast, Massachusetts Chapter 93A is highlighted as being unusually powerful, specifically because it covers the core of our listeners' business, B2B enterprise sales.
Right. Most consumer protection laws focus on transactions with individual consumers.
That's right. But Chapter 93A, Section 11, applies specifically to business-to-business disputes. This is critical. It covers high-value, complex AI platform sales between 2 large, sophisticated parties. If a salesperson in Boston sells a fraudulent AI analytics tool to a major financial institution, 93A gets triggered.
And the mechanism for escalation is unique. The 30-day demand letter.
This is a major procedural tripwire. Before filing a lawsuit, the plaintiff must send this 30-day demand letter describing the deceptive practice, the AI washing. The salesperson, or the company, has to respond with a reasonable settlement offer within that 30-day window.
And if they don't?
If they fail to make a reasonable offer, and a court later finds a violation occurred, the court must award attorney's fees to the plaintiff and can award up to treble damages.
This transforms customer service into a matter of urgent legal strategy. You can't just ignore a customer complaint about fake AI functionality, because that complaint is the fuse for a potential treble damages lawsuit where you are personally named.
It incentivizes everyone to settle quickly, because the penalty for guessing wrong on the reasonableness of your offer is potentially punitive damages.
Okay, let's go to the West Coast. California's legal landscape with the CLRA and the UCL. The CLRA has specific prohibitions against misrepresenting goods.
Yes. The Consumers Legal Remedies Act prohibits 24 specific deceptive practices, including the highly relevant one of misrepresenting that goods have characteristics they do not have. If you sell a self-learning AI model that's actually a static algorithm, you've committed that violation.
And our sources drew a fascinating analogy here between AI washing and drip pricing that makes California a hotbed for class action risk.
This is a very clever legal maneuver. California has been aggressive in targeting drip pricing, advertising one low price and then adding hidden mandatory fees later.
Right.
The analogy to AI washing is powerful. If a company advertises automated AI for $10,000 a month, but hides the fact that the automation requires expensive, undisclosed human oversight or consulting just to function, that human intervention is essentially a hidden mandatory cost.
So the sales professional misrepresented the true cost of achieving the claimed outcome.
Exactly. It gets framed as a deceptive pricing practice under the CLRA and the UCL, opening the door for widespread class action lawsuits targeting those who marketed and sold the deceptive product.
And finally, let's touch on New York. General Business Law, Section 349, is potent because of its incredibly low threshold for proof.
GBL Section 349 prohibits deceptive acts or practices in the conduct of any business. What makes it so dangerous is what the plaintiff doesn't have to prove. They don't need to prove the salesperson intended to deceive, or even that they knew the claim was false.
So no scienter required at all?
None whatsoever. They only need to show 2 things. 1, the act was objectively misleading in a material way, and 2, it caused injury. That is a very low burden to meet. A sales rep who accidentally overstates the capabilities of a system, genuinely believing the marketing hype, can still be found personally liable.
Because their statement was objectively false and materially misleading to the customer, "I didn't mean to lie," is simply not a defense.
Not under this statute. It shifts the entire burden of verification onto the salesperson, turning every pitch into a personal legal audit.
We need to contextualize this current AI risk by looking at previous technology bubbles. The sources point to historical collapses to predict the future of AI liability. Let's start with the archetype of modern tech fraud, Theranos.
Theranos is the foundational case study for what happens when fake innovation collapses. Elizabeth Holmes promised the Edison device could run hundreds of blood tests on a single drop of blood. They raised over $700 million on this promise.
But the device fundamentally did not work. And the key lesson for our audience is that the fraud wasn't just contained in the lab. It had to be operationalized by the commercial teams.
Exactly. The fraud was executed through the sales and business development teams. They're the ones who secured massive contracts with partners like Walgreens and Safeway based on rigged demos and outright lies. The precedent here is clear. You cannot use trade secrets as a shield to hide the fact that a product simply does not exist.
And this directly informs AI washing. If a sales leader pitches a VC based on AI revenue, that is actually just hidden consulting revenue from the humans they swore were automated, that's a clear line to securities fraud.
The sales team is the commercial interface of the fraud. If the product is vaporware, the sales team becomes the physical mechanism by which that fraud is perpetrated against the customer.
The crypto bubble also provided crucial precedents, especially by expanding the definition of who counts as a seller in the digital age. Let's talk about BitConnect.
Right. The Wilds v. BitConnect ruling is extremely important for anyone in AI sales who uses digital channels, social media, or webinars. The court ruled that online promoters who posted videos hyping the BitConnect Ponzi scheme could be held liable as sellers under the Securities Act of 1933.
Even though they argued they were just providing mass communications, not physically selling anything.
And the court rejected that defense completely. They said solicitation via YouTube video is functionally no different than a personal letter if it directly solicits investment. This decision critically undermines the defense of, "I just posted about it on LinkedIn," or "I just did a webinar." If you are soliciting sales via social media using false AI claims, you may be treated as a seller.
And the FTX lawsuits against celebrity endorsers show the massive reputational risk when a personal brand is leveraged to lend credibility to a fraudulent scheme.
And while sales reps aren't necessarily movie stars, high-profile AI thought leaders or VPs of sales with large industry followings need to heed this warning. When you lend your personal brand and credibility to a fraudulent scheme, you become part of the apparatus of deception. Plaintiff attorneys will specifically name those individuals to prove their endorsement was relied upon by victims.
Let's pivot from litigation risk to the immediate threat from your own employer, the commission clawback.
Clawback provisions are now ubiquitous in compensation plans. They allow the employer to recover commissions previously paid out if a sale is canceled, refunded, or, critically for our topic, procured through a violation of company policy.
And fraud is a primary trigger.
It is. In the company's eyes, if the sale was fraudulent, the commission was never legally earned under the terms of the contract. They can simply deduct the amounts from future paychecks, or, if you've left, they will sue you for repayment.
And the legality of this varies. What's the contrast between, say, California and New York on this?
California is generally very protective of earned wages. Once a commission is defined as earned, it's protected. However, employers can argue that if fraud was involved, the fundamental condition for earning it, a valid contract, never occurred. It becomes a complex legal battle.
And New York has the faithless servant doctrine, which sounds harsh.
It is harsh. New York courts have upheld it. It requires employees who engage in misconduct to forfeit all compensation earned during the period of that misconduct, not just the commission on the bad deals.
So if you were AI washing for 3 years, you might have to return 3 years of salary and commissions.
The risk of forfeiture is immense.
This leads us to the catastrophic scenario you call the double whammy. Let's paint a vivid picture of the personal financial ruin this enables.
This is the financial collapse that happens when all these legal threads converge. First, whammy. Termination for cause. You're fired for violating the code of conduct. That instantly voids any unvested stock options or equity. Your retirement plan just vanished.
Second, the company demands repayment of all commissions via the commission clawback.
Yes, That's hundreds of thousands, maybe millions, demanded back. Third, you're personally sued by the customer or the regulator, and you have to pay for your own personal legal defense costs because indemnification was denied. You are paying 6 figures a month to defend yourself.
And finally, the fourth whammy, reputational ruin.
The stain of fraud makes finding a new role, especially in regulated sectors, nearly impossible. You're unemployed, you owe the company back payments, you have massive legal bills, and no future income. You go from a high-income executive to facing personal bankruptcy very, very quickly. This is the existential risk you take when you sell a lie.
The message is clear. If you are in the middle of a company selling vaporware, or if you've been ignoring red flags, you need a strategy for self-preservation. Section 5.1 is about the death of a crucial legal shield, the Janus defense.
This is a critical legal history lesson for SEC liability. For years, after a 2011 Supreme Court ruling called Janus, there was a strong defense for the messenger. That ruling held that only the maker of a false statement, the one with ultimate authority over the content, was liable.
So if marketing wrote the lie, the sales director who read it was often protected. That sounds like a safe harbor. But that shield has now completely collapsed because of a 2019 ruling, Lorenzo v. SEC.
The Lorenzo shift expanded liability under other parts of the law, specifically focusing on what's called scheme liability. The Supreme Court held that a person who disseminates false statements with the intent to deceive can be liable even if they didn't make or write the original statement.
Because they're participating in the overall scheme.
Exactly. So, before Lorenzo, if marketing wrote the pitch deck lie, you might have been safe. Now, if you are a sales director and you forward a deceptive pitch deck to investors and you know the AI claims inside are false, you are liable for participating in the fraudulent scheme. The defense of, I just forwarded the deck, is dead.
It's the knowledge of the lie that transforms the act of forwarding an email into a criminal act.
And that leads us directly back to the red flag doctrine, which we can now detail as the salesperson's duty of inquiry. Courts are actively trying to prevent individuals from manufacturing ignorance as a defense.
This is the idea that if you suspect the truth, but deliberately avoid confirming it to maintain deniability, that willful blindness is treated as actual knowledge.
The courts require your reliance on company materials to be reasonable. If you're selling a highly complex, multi-million-dollar system, the court expects you to exercise reasonable professional care.
Let's run the classic willful blindness scenario in AI sales.
Okay. Imagine you're a sales engineer demonstrating a new autonomous AI customer service tool. You notice in the back-end logs that response times for complex queries are only instantaneous during business hours in a particular foreign time zone. You notice the responses sometimes contain phrases that sound suspiciously human or look like they were copied and pasted from a manual.
You suspect the Wizard of Oz scheme?
The red flags are waving.
If you deliberately choose not to ask the CTO, show me the proprietary model running in real time, just so you can maintain plausible deniability, that is willful blindness, the court will impute actual knowledge to you. You deliberately chose ignorance to secure the commission.
And this duty is magnified the higher you rise in the organization. Absolutely. High-level enterprise sales executives are expected to be sophisticated parties. You cannot claim ignorance of a fundamental product flaw when you've been paid hundreds of thousands of dollars to be the expert representative of that product.
Okay, this is the survival guide portion for our listener. If you need to audit your own risk, what are the actionable defensive steps you should take, starting even before you accept a job offer?
You have to adopt a defensive posture from day one. You need to ask questions that penetrate the veil of hype.
So, assessing the risk of vaporware before signing, what's the first question on the checklist?
Data provenance. When you're interviewing, you must ask, where does your training data come from? Is it proprietary? Most importantly, do we have clear licenses for it? If the answer is vague, oh, it's just public data, that is a major red flag for IP and compliance risk.
Next, the Wizard of Oz test question.
Ask specifically and demand a number. What percentage of the workflow is fully automated versus human in the loop? And is this ratio formally disclosed to clients in the contract? If they refuse to disclose the percentage, you know the human element is being intentionally hidden.
I also like to request to see the actual mechanics.
Yes. Demand the live demo and audit log test. Can I see the back-end logs of the AI processing a non-scripted request in real time? If they refuse to show you the log files, they are likely hiding something fundamental.
Now, what about protecting yourself once you're in the deal contract hygiene? The sales executive has to influence the paperwork.
You have to. You need to ensure the scope of work, the SOW, accurately describes the product as it exists today. Never let a pitch deck or verbal promise contradict the written SOW. And if you're selling a roadmap item, it must be explicitly labeled in the contract as future functionality, with no guarantee of delivery date.
And the mantra must be to eliminate absolute claims.
Yes. Avoid the specific, verifiable lies. Replace 100% accuracy with target accuracy of X% based on internal testing. Replace the high-risk term autonomous with automated workflows, which clearly implies a system that performs a function but doesn't rule out human oversight. You have to influence the contract language to reflect verifiable reality, not marketing fantasy.
For those who might be trapped in a company selling vaporware, where the red flags are undeniable and the personal risk is too high, the SEC whistleblower program offers a potential lifeline.
It's a rational survival strategy. The Dodd-Frank Act established this program to reward individuals who provide original information that leads to a successful SEC enforcement action over $1 million. The award is 10% to 30% of the money collected.
Given the scale of some of these AI fraud cases, that could be a multi-million-dollar payout for providing internal emails that prove the fraud.
It's an incentive designed to weaponize internal knowledge, and whistleblowers can report anonymously if they are represented by an attorney, mitigating some of the immediate blowback.
And even if they sign a tough NDA on the way out, the SEC provides legal protection.
Crucially, yes. SEC Rule 21F17 explicitly prohibits companies from using NDAs or separation agreements to legally stop an employee from reporting fraud to the SEC. You cannot be legally, contractually bound to hide fraud from the federal government. The law protects your ability to report the truth. This makes the whistleblower path not just a moral choice, but often the most financially sound, rational choice for self-preservation.
So what does this all mean for the future of enterprise technology sales? The Wild West era of AI sales? It's officially over. The convergence of federal regulators and powerful state laws has created this dense, unavoidable web of personal liability.
The implications for the sales professional are profound. The messenger is no longer protected by the corporate shield or by claiming good faith or by claiming ignorance if they willfully ignored red flags. Individual verification is now a prerequisite for legal and financial survival. Selling a hallucination today risks not just a commission check, but your entire career, your personal assets, and potentially your freedom.
It requires a fundamental shift in mindset. You have to become the first line of defense against AI washing, rather than an unwitting and ultimately disposable accomplice.
And the source material really suggests the personal risks. The financial ruin, criminal exposure, reputational damage are now so high that the traditional stigma of whistleblowing is being overridden by the logical necessity of self-preservation. For those in the middle of an AI washing scheme, the calculus is changing dramatically. Is being a whistleblower or an unwitting accomplice the greater career risk?
The knowledge we've unpacked here demands immediate action. What steps must you take this week to audit your current sales claims, to verify the technical reality of your product, and to protect yourself from the inevitable collapse of the hype cycle? That is the question you have to answer right now. Thank you for joining us for the deep dive. We hope this has given you the facts you need, not the hype you hear everywhere else.